Welcome back to Prof. Dan US Green Card. If you are a returning viewer, thank you for being part of this community. If you are new here, my primary focus is on self-petitioners, especially EB1A Extraordinary Ability and EB2 National Interest Waiver cases. Please hit that subscribe button right now for regular updates. This is really exciting. Just as I predicted in my last video, that based on historical trends in 2024, in 2023, and in 2022 October Visa Bulletin, beneficiaries were asked to use the date for filing chart. Guess what? USCIS has just confirmed that for October 2025, all family-sponsored filings, which is beyond the scope of this video, and employment-based preference categories must use the date for filing chart. And this is absolutely massive news. I'm going to break this all down, exactly what this means, and I will use the EB2 preference category as our example, because I am very sure thousands of people, thousands of beneficiaries can now file their adjustment of status application, both in the US and those that are abroad. So, for EB2 rest of the world applicants, that is, all other countries except for China mainland born and India, the date for filing chart shows July 15, 2024. This simply means if you have an EB2 priority date that is before July 15, 2024, you can now file your I-485 adjustment of status application immediately. Please go ahead and check your approval notice that was mailed to you from USCIS to reconfirm your priority date. Let me make this crystal clear. If your priority date is July 14, 2024, or any date that is earlier than that, you are eligible to file right now. If your priority date is July 16, 2024 or later, you still cannot file. You must wait. These dynamics makes us to realize that just one day has a significant effect as far as these immigration benefits are concerned. Similarly, for China-born EB2 applicants, the filing date, as you see on the screen, is December 1, 2021. So if your priority date is November 30th, 2021 or earlier, you can file. Similarly, for the Indian-born EB2 applicants, the filing date is December 1, 2013. It means if your priority date is November 30th, 2013 or earlier, you can file. I know some of you may wonder why USCIS made this decision. It has been clear that whenever there are more immigrant visas available for the fiscal year than there are known applicants for such visas, then the date for filing will be used. And this is exactly what we've hoped for at the start of fiscal year 2026. The official USCIS language confirms that when they determine visa availability exceeds the demand, then they allow use of the more favorable date for filing chart. And in this case, the date for filing for the October Visa Bulletin is more favorable than the final action date. This has given more beneficiaries to have the opportunity to progress with their adjustment of status. And of course, this decision perfectly validates the historical pattern I mentioned. USCIS used the date for filing chart for October in 2022, 2023, 2024, and now in 2025. So this 4-year consistency shows October is typically a month of opportunity due to perhaps the new fiscal year's visa availability. Hopefully, we're going to see more of this progress. I know some of you would never expect this and haven't prepared for this. You probably think, what can I file? So if you are now eligible based on this filing date, you can probably start with watching some of my videos on adjustment of status. There, you're probably also going to learn that you can submit your Form I-485 along with all supporting documents, including your medical exam, employment letter, and their required fees. You must remember, filing this adjustment of status doesn't also guarantee approval. However, it starts your adjustment process and provides important benefits like work authorization eligibility. And yes, let me tell you, even during adjustment of status, beneficiaries still receive RFE, request for evidence, the same many of you received while you file your Form I-140 petition. But eventually, you may get approved or you may not. So you want to make sure you do it right. My educating advice to you would be, always be proactive. Don't wait if you are eligible. USCIS can change these determinations month to month. What's available in October visa bulletin might not be available in the November 2025 visa bulletin. So if your priority date qualifies, gather your documents and file as soon as possible. You can check my playlist. I have a comprehensive video on the adjustment of status process that also walks through from I-485 step by step. Watch that video to understand exactly what documents you need and how to prepare your application properly, including medicals, conducting your medical examinations, where to go to within your location as approved or authorized by USCIS, and the likes. Now, I want us to address a specific question I received from one of my viewers, and I think many petitioners will be in this category, and I hope any of these educating insights I share, you may probably find it useful. However, please do know everybody's case is different, and you may want to consult an immigration lawyer. The person wrote, "Good evening, Prof. Dan. My priority date is May 14, 2024. My I-140 is still pending, not approved. If USCIS decide to use date of filing, can I file an I-485, that's the adjustment of status now? Please take note, this is for an EB2 NIW case." Now, this is a great question. And now that, truthfully, the date of filing has been confirmed to be used for the October visa bulletin, what should this person do? Now, for me, I think, to the best of my understanding, from all what I know from credible USCIS sources, I think the answer is yes. You can absolutely file your Form I-1485 with your pending EB2NIW I-140. Now, with your priority date of May 14, 2024, that is before the July 15, 2025 cutoff date for the EB2 rest of the world in the date for filing chart. So that means you are eligible to file concurrently. But again, I think this is going to raise another strategic question, like, should this person do the premium processing now to get his or her I-140 approved first, or should this person file concurrently while it's still pending? I mean, the I-140 is still pending, which you don't even know if it's going to be approved, denied, or you're going to get RFE. Please, If you are knowledgeable about this and you are watching this video, can you help us put some comments in the chat on how best you think this person should proceed? While you're trying to make your decision, if you fall in this, category, I just want you to think about the following. For EB200W cases specifically, you should note that premium processing has different timelines than other I-140 categories like the EB1A. For EB1, for example, premium processing takes 15 business days. However, as far as the EB200W is concerned, if you do the premium processing, we see that it takes 45 business days. And that simply means about 9 weeks. Also put to consideration, the premium processing fee is $2,805. And that only guarantees a decision which could be approval, denial, or request for evidence within that time frame. It doesn't guarantee approval. And if many people fall in this category, and people now decide to quickly go and do premium processing, that also means we're going to have lots of applications submitted to USCIS. Could that also mean something? Could that also mean there could be delay? Yes, I do know that some persons have been fortunate, even though it's within 45 business days, we've had petitioners who did premium processing, who received the response within 15 days, within 20 days, less than the 45 business days. And we've had people who it is on the 45th day they got response. So it's unpredictable. Also, consider the following pros. I will just speak briefly about premium processing or concurrent filing. What should you do now if you fall in this person's category? Now, one of the pros, I think, for premium processing is you get certainty that in about 9 weeks, you will get something from USCIS. And if approved, peradventure, you can file your I-485. The cons, however, is that 9 weeks puts you into late November or early December. And by then, the November visa bulletin, who knows, may revert to final action dates. In my own prediction, that will most likely be the case. And if that happens to be the case, you would lose this incredible date for filing opportunity entirely. And perhaps you would be stuck waiting for your priority date to now become current again under the final action chart. And if someone else says, well, maybe I should just do a concurrent filing. Normally, what concurrent filing means is maybe when you submit your I-140 in the very beginning, when you don't even know if you're going to be approved or not, you also submit your adjustment of status application at that point in time. That's an example of concurrent filing. So if that is what you now want to do now, for you that you already have your I-140 pending, I would say, well, you can file immediately while these rare dates for filing opportunities still exist for the October visa bulletin. Among other things, you can get your work authorization, that's your EAD, and maybe travel benefit like the advanced parole, while still waiting for your I-140 that is still pending. And by that, you are now protected by authorized stay status, so you won't probably accrue any unlawful presence. The cons, however, is that if your I-140 gets denied, because that has been the case of some other persons who file concurrently, but eventually they didn't get approval. If you get approved, that is thumbs up, all good. What if it is denied? What if you still get an RFE? In that situation, if it's denied, your I-485 is automatically denied also. Remember, you would have spent more money because you file concurrently than if it were to be just the premium processing. And in such case, you'd lose both sets of the filing fees with no refunds. USCIS will never refund you. So I would say For EB-2NIW cases, if you find yourself in this situation, it is a significant financial risk, and you may probably consult an attorney for the best advice. If you know you are a doubting Thomas, you know what you submitted. You self-petitioners, you know what you submitted. You are not kind of sure if you're going to get approved or not. So consider that when you are making your decision. Think about your I-140 case strength, honestly. You know that the EB-2NIW cases require meeting the three-pronged test: substantial merit and national importance, well-positioned to advance the endeavor, and beneficiary to waive the job requirements. So if you are confident you meet these standards with strong documentation, and you have the financial backing, and you are ready to risk it, then you might say, I want to do concurrent filing. But then consider the opportunity cost as well. Like I've said, the date for filing chart is showing July 15, 2024. And I doubt if we're going to see this kind of opportunity open up again. And missing this window for the sake of I-140 certainty could mean waiting much longer to file your I-485. So some of you may be pressed with time, and you may have the financial means, then you want to consider making your decision. But if it's otherwise, you're not even sure of the strength of what you submitted, or you don't even have the financial capacity, what can you do other than to just wait? In all of this, just rethink and make your final decision. I wish you all the best, whatsoever decision you make. Again, a big round of applause. Congratulations to every self-petitioners who already have an approval, whose date has now become current. Congratulations. Go ahead and progress with your adjustment of status. It's my hope that you will also get an RFE, and if at all you get an RFE, eventually you should or you will get approval. And of course, yay, you get your green card. All the best. Please share with your loved ones. Many people do not know about this. Please share with them.